You believe your doctor was careless, causing you significant harm and injury, and now you want to go ahead and sue him. You want to find an attorney who's not going to sue him, but rather is going to threaten the doctor with a lawsuit and expect that the doctor's going to throw his hands up and say, "You're right. How much do you need?" and write you out a check for your entire damages amount. Will they do that? Can you go ahead and threaten the doctor with a lawsuit and expect that he's going to go ahead and accept your terms and write you out a check? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You think that's going to work? I'll tell you, I've been in practice more than 29 years here in New York, and I will tell you right now, that will never, ever work. If you threaten a doctor with a lawsuit, hoping and expecting that he's now going to go ahead and roll his hands up and say, "You're right, I accept responsibility, I screwed up, tell me how much money you want and I'll cut you a check right now." Well, guess what? That is not going to happen. It is never going to happen. If you write the doctor a letter, or your attorney writes the doctor a letter threatening a lawsuit, unless they go ahead and cough up money, you know what they're going to do? They're going to throw that in the garbage. Now the doctor is going to take that letter, send it off to his insurance company. And you know what they're going to do? They're going to laugh at it. They're going to throw it in the garbage. They're going to say, "So what? You're threatening us? Go ahead, sue us." Why? Because these insurance companies vigorously represent the doctors repeatedly, over and over and over again, and they will do everything possible to fight you tooth and nail on these types of cases, specifically these medical malpractice cases. They want to show the doctor that they stand in solidarity with them. In order for you to know whether or not you actually have a valid basis for a case, we have to go ahead and gather all of your medical records, read every single page of your medical records, and then send your records out to a board-certified medical expert to determine, number one, was the doctor careless? Did he violate from the basic standards of medical care? Now, if he did, was that carelessness a cause of your injury? Yes or no? If the answer is yes, then the question then becomes, what type of injuries, what type of damages do you have? How badly injured are you? Is it permanent? Is it significant? If the medical expert confirms that you do have a valid basis for a case, now we can approach the doctor, now we can approach the doctor's insurance company and say, "Listen, we've had an opportunity to review all of the medical records. We've had an opportunity to have a world-class medical expert evaluate this as well. And he determined that we have a valid basis for a case. So now we'd like to give you the opportunity to go ahead and evaluate this on your own. Here are copies of all of the medical records that our expert reviewed. And now we ask that you come back to us with a decision about whether you agree or disagree." Now, in all likelihood, they're going to come back and disagree and say, "Thank you for that offer, but no, we're not going to accept your offer." Which means now we have to go ahead and actually file a lawsuit. The mere threat of a lawsuit is actually very dangerous, and I'll tell you why. Not so much dangerous for you as an injured patient who wants to bring a lawsuit or wants to try and resolve your case without the need for going to court, but dangerous for the attorney. And let me tell you why it's dangerous. You see, in New York, if an attorney actually goes ahead and threatens litigation without any intent whatsoever of going forward with a lawsuit, the attorney has now violated the ethical rules and now is subject to ethical grievances against him. And now he's got a big problem. Why do I share this with you? I share this with you just to give you an insight and an understanding, because so many people say, "You know what, let's just send the doctor a letter that threatens litigation." Well, no, it doesn't work that way. Nothing's going to happen. It's going to be laughed at, and now the attorney is subject to having an ethical violation based upon no intent to sue. But if, on the other hand, you do it the way I described, by getting your case fully evaluated, now we have a confirmation by a medical expert that you do in fact have a good case. Now we can reach out to the doctor and to the insurance company and say, "Look, here's why we believe we are more likely right than wrong that your doctor, your client, your insured, violated the standard of care, causing my client all of these injuries. We invite you to come negotiate with us to try and resolve this before we ever start the lawsuit." And if they turn around and say thank you, but no thank you, now we go ahead and actually start the lawsuit on your behalf. You know, I do recognize you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but are thinking about doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.